Hello, everyone, and welcome to the channel, Ontario Law and the Older Person. And today we're going to talk about filial responsibility laws. Filial responsibility laws are laws that enable parents to sue their adult children for financial support. And a lot of people don't know such laws exist, including a bunch of lawyers. And we have them in Ontario. We have them in other provinces in Canada, and there are other countries that have laws like this as well. I'm going to be focusing just on the law in Ontario. The warning: the information provided in this video is not legal advice. It is relayed for the purposes of general information. No legal decisions should be made based on this material. Any viewer who needs legal advice should contact a lawyer. So to find the source of these laws, we go to the Family Law Act, and this is purely for Ontario. The section is called Obligation of Child to Support Parent. Section 32. Every child who is not a minor has an obligation to provide support, in accordance with need, for his or her parent who has cared for or provided support for the child, to the extent that the child is capable of doing so. So every time I tell someone about this section, they all think, yay, this is a wonderful idea, but they're thinking of well-off children letting their saintly parents exist in some hellhole residential place. And there's not a lot of case law about it, but in the case law, we've only got one person who could be considered well off, and that's because she happened to win a lottery. So most of the time, these are adult children who are not able to splash around a lot of money. That's not saying I think there should be no sense of moral obligation. I'm just saying the go-to thought should not be, oh, these selfish, spoiled adult children who are just ditching their parents. It's usually not the case. And then order for support, section 33, subsection 1, a court may, on application, order a person to provide support for his or her dependents and determine the amount of support. So in this case, the parent might become the dependent. This is the three-step test, if you will, to determining whether an order for payment should be made. So does the parent actually need support? Did the parent act as a parent by either caring for the child or providing financial support? And does the adult child have the ability to pay? All of these questions need to be answered by a yes, otherwise an order won't be made. Section 33, subsection 5. In an application, the court may, on a respondent's motion, so the applicant has started the case, this is the respondent, so they have a motion where they might ask to add as a party another person who may have an obligation to provide support to the same dependent. So what I put here is, for example, if a person, respondent, is facing an order to support someone, applicant, and the law says there's an additional party who might also have an obligation to financially support the applicant, the additional party can be made a party to the proceeding and could also be ordered to provide support. That is, at least technically. This is subsection 9 of that section, and the title for it is called Determination of Amount for Support of Spouses, Parents, not children. There's another process for that. And then there are sections that leave out parents. So not all sections apply the same to all possible dependents. So subsection 9. In determining the amount and duration, if any, of support for a spouse or parent in relation to need, the court shall consider all the circumstances of the parties, including A, the dependents and respondents' current assets and means, B, the assets and means that the dependent and respondent are likely to have in the future, C, the dependent's capacity to contribute to his or her own support, D, the respondent's capacity to provide support, E, the dependent's and respondent's age and physical and mental health, F, the dependent's needs in determining which the court shall have regard to the accustomed standard of living while the parties resided together, G, that's more about spousal support, but it is touched on in a couple of court decisions. Anyways, moving on to G, the measures available for the dependent to become able to provide for his or her own support and the length of time and cost involved to enable the dependent to take those measures. So for example, can they apply for some kind of pension, or could they, go to school and get more skills to get a job of their own, stuff like that. So I skipped some here. So subsection 8, any legal obligation of the respondent or dependent to provide support for another person. So for example, does this adult child have children of their own? Well, they're the ones that they have to support. Or same thing, do they have a person who is entitled to spousal support? Well, probably the court will say, okay, this person is already paying spousal support. They don't have extra money to give to a parent. So there's a kind of ranking concept with these responsibilities. And then down to M, any other legal right of the dependent to support other than out of public money. So we're not talking about some kind of pension or disability support. We're looking for other sources. So what I have here as an example, are they entitled to support from someone else's estate? So if this is, let's say, a widow who is entitled to ongoing support from the estate of their late husband, so that's part of the calculation. Now, while the section that is currently relevant is in the Family Law Act, we actually had earlier statutes that were specific just to parents. And I'm not going to read through all these. I just wanted to bring the dates to your attention. So from Saskatchewan, the Maintenance Order Act from 1921. And then from BC, the Parents Maintenance Act 1922. Then we have from Ontario, the Parents Maintenance Act 1921. We then have the Parents Maintenance Act 1933, the Parents Maintenance Act 1933. Why am I making these dates clear? Um, so people have put these statutes in place because they feel young people have lost all their morality and do not respect their parents and aren't willing to take on their responsibilities when it comes to taking care of their parents. So this is not a new thing. These laws, which are the earliest laws that were made in Canada back in the 1920s and 30s, that's also when they were used the most. What do you think was happening back then that might make it difficult for younger people to support their parents? Context. So, World War I, which was from 1914 to 1918, left Canada broke. And not a lot of people know that. A lot of our history tends to focus a lot on World War II, where we were left with a really banging economy. They don't know as much about World War I. So we were going through hard times. And then remember, because of the war, many young men died in the war. And then from the Spanish flu, which was from 1918 to 1920, many young men and women died of the Spanish flu. So we have a lot of people who would have been the principal wage earners and caretakers who died. And then 1920s, people seem to think the 1920s were a great time, full of jazz and flappers and liquor, but for most people it was very hard. So we had stagnant wages because, employers were being scumbags and rising prices. So there's also a lot of talk about, all these goods were being made, so all of these gadgets. But the thing is, the people building these refrigerators or the radios were often not even able to pay for them themselves, and therefore they were building a lot of stuff that no one was buying, and that was part of the economy starting to crash. And then the 1930s, the Great Depression. So I think we can see reasons why people might not be able to support their older parents that have nothing to do with them being lazy scumbags. I hate it when we trash younger generations. You'll find that out about me. Then there was a massive dip in these cases from the early 40s to the 70s, and that's because the Canadian economy during those decades was relatively strong, and then increased use in the 70s. And so now we have the economy like jumping up and jumping down in a much more constant fashion, I guess. It's happening more that we have these rises and dips. And so the use of these laws is 100% tied to the Canadian economy, but people don't want to talk about that. They'd rather just blame young people, starting in 1921, for their failures to meet their moral obligations. Arguments in support of these laws. 1. These laws represent society beliefs that older people deserve support, which of course they do. 2. The money paid can subsidize what an older person receives from social assistance. 3. Government money that might have been needed to support that older person can go somewhere else. 4. It makes sense to expect family members to provide support for their parents as they are expected with children and ex-spouses. Arguments in opposition. And really, there tends to be opposition rather than support for these laws. But so here are some of them. Monetary payments from adult children don't address issues such as housing or personal care. Older parents in need tend to have children who are not necessarily better off, which means we might be passing down financial stress from one generation to the next. Therefore, the amounts required to pay might not amount to much. So, do the adult children have the means to pay enough that it actually is meaningful to the parent? It could be seen as a tax limited to those with indigent parents. Given the destructive nature of litigation, adult children who might have been providing day to day care, such as doing chores or bathing, might become unwilling to continue providing such care. And of course, to pay someone to do all this, it's an enormous amount of money. And then there's the idea that children shouldn't be required to support parents as children didn't ask to be born. That's kind of a tough one. There's a lot of people who think children should be inherently grateful and willing to do everything. And then others were saying, hey, you chose to have me. I didn't choose to be here. So we'll see. Other issues to consider. So the lifespan of older people is longer. And we're also talking about more older people. So we're not just talking about people living past 60, we're talking about more people living past 80 and more people living past 100. So the plans they might have made for retirement might not be sufficient. And, there's also this pressure for people to retire at a certain age. There's also pressure saying not to, but it's still a reality that most people retire in their 60s. So they might have another 30 years where they are dependent on a pension, which probably won't be rising according to cost of living. There's all sorts of issues involved in when people are living older. So not necessarily the same set of circumstances as we had back in 1921. Given longer lifespans, adult children could be required to pay for decades, which interferes with their ability to establish their own financial security and planning for their own retirement. So, again, it's financial hardship that might be passed down from one generation to the next. In the face of drastically rising costs, is it just to expect younger people to provide support for their older parents? So we know, for example, younger people are finding it much harder to buy a house than they did in the past. And then we have difficulties with skyrocketing cost of rent. And again, the wages are stalled. So this is where we are. So is it fair to just put this extra financial responsibility on adult children? Changes in family patterns can result in someone having multiple parents. What if their biological parents divorced and then remarried? In Ontario, step parents can be ordered to pay child support. Should that obligation operate in reverse? So in Ontario, basically anyone who has really shown the intention of raising a child, possibly because they married their parent, can be on the hook for child support. But also, and this might seem a little out there, but what if we're talking about polyamory, right? We have three or four people who are in a dedicated relationship and there are children involved. So, how complicated might this get? So, just an idea. Okay, should the government be let off the hook for providing adequate care for older people just because those older people have adult children? And then older people might find it harder to keep or find employment due to age discrimination. Does that mean adult children should be required to provide financial support? So because someone else is acting in a way, like potential employer, in a way that violates the Human Rights Code, does that mean that the children should be on the hook for making up basically for that age discrimination? Now I'm going to touch on a number of cases that address this issue, but don't worry, they're not very long. I just wanted to point out different kinds of arguments that can show up. And yes, I will probably be butchering the names of some of these cases. I'm sorry. So we have Man Clark and Man Clark. This is a case from 1925. A mother sued her son for support while living with her daughter. The judge didn't order the son to pay since the mother wasn't considered infirm or in need due to her current circumstances. So pretty easy there. Blum and Blum. Mother sued son for support because she found it impossible to collect the spousal support she was entitled to from her ex. The son had been providing her financial support while hiding the assets of his father. He was ordered to pay support, but it was less than what she needed and what she had been getting originally. The son cut her off anything more than the ordered amount. And this is actually a really messed up case. what happened was the father transferred the assets to the son, and this was illegitimate in these circumstances. This is a stunt people pull in family law as they try to lower their assets, get rid of their assets. It's an illegitimate transaction, and also the court was going after the son because the father flat out was refusing to pay, and then she ends up with a worse financial situation because of this whole thing. I think the judge is kind of nuts with this, and it's a very unfair result. Brent and Brent from 1987, a stepmother failed in her attempt to get financial support from her stepsons as they had been adults when she married their father and she hadn't played a parental role. So she basically didn't qualify as a parent. And then, no idea how to say this name, Baddeley and Baddeley, an ex-husband successfully sought to have his ex-wife's son added to the case given the son's obligation to support his mother. So there's no final decision for this case, so I don't know what ultimately happened. So yes, the ex-husband was on the hook for paying spousal support, so he wanted the son added because the son possibly owes support. So this case is from 1989. This is actually a very important case. It's cited a lot in other cases, and it's also fairly long, has a lot of stuff going on. I have cut it down to the bone. So Godwin and Bull, so sorry, from 1993. A woman sued 3 out of 4 of her adult children for financial support. One of the issues the children raised was that she hadn't been a good parent, hadn't been supportive of them, and hadn't protected them from their abusive father. And the judge found in the mother's favor. Now, technically, you're not supposed to consider that aspect of the relationship, or at least not at the time this case was decided. It's basically, did they provide financial support or physically take care of the children? And in this case, she definitely physically took care of the children and also was part of their adult life as well once they left the home. Anyways, the judge found in the mother's favor. To do this, the judge compared her behavior according to what was considered acceptable parenting at the time. That her own parents hadn't been great, so she hadn't been given parenting skills by her parents, and that she was limited with what she could do about her husband given her lack of resources. She was basically the stay-at-home parent. Since then, she has done her best to earn money, but is finding it difficult to find work due to her age and lack of experience. The judge also determined that there had been positive aspects to the relationship. So she hadn't been 100% the best. She had been a little gruff and cold at certain situations, but she definitely did her best. And again, thinking about what kind of parenting was expected at the time. So looking into context. So the judge did find in her favor, but unfortunately, the court case destroyed what little positivity was left. And that's what litigation does. And that's why a lot of lawyers often urge settlement, especially when it's a family situation, because once you get into a courtroom, you're being encouraged to say the worst thing about the other side, and it's on the record, and it does destroy whatever good aspects of the relationship might remain. Burgess and Burgess from 1994. An ex-husband sought to have his earlier spousal support payment lowered due to a material change in circumstances. And so that's kind of an official term for what it sounds like. So let's say someone is ordered to pay spousal support based on their income, and their income was originally $100,000. But now something has happened. For example, they got fired and had to find another job and they could only find a job for $50,000. As long as that's a legitimate change, they're not deliberately underemploying themselves, they can go back to the judge and say, listen, Your Honor, this is what happened. I can no longer pay that amount. And the judge is likely to order a lowered amount. Now, in this case, the material change in circumstances, according to the ex-husband, was that the ex-wife's adult son had become employed and owed his mother support according to the law. The judge disagreed that this was a material change in circumstances. After all, it's not the ex-husband who has a change in their circumstances. It's not the ex-wife who has a change in the sense that she didn't get a job or inherit a fortune or anything like that. So it might be reaching too far to say her son now has more money. Anyway, so the judge didn't buy into that argument. The judge also found that the son couldn't afford it. While he and his wife made a good salary for the time, they were saving in order to start a family, which the judge found a good use of their money. So it's not purely a matter of how much money do they have. It's also what their plans are for their own money. And there's this concept where, people should be given the opportunity to create their own financial footing. They need a chance. They should be able to save. They should be able to build themselves up a bit before we start looking at how much extra money do they have that can go to their parents. Whiteley and Brody from 1994. An ex-husband failed to get an order that the ex-wife's children should pay support. The judge felt that obligations from the ex-spouse ranked higher than those for adult children. The judge also noted that there wasn't an equal mutual obligation between parents and children, as the parents made the choice to have children while children didn't choose to be born. Here's an interesting thing between Canada and America that I looked at for other research. Americans seem to really emphasize this idea that children should be grateful just for existing. And if you look at the court cases from America, which I did a bunch, they're a lot less flexible when it comes to what children should be allowed to do with their money before they get dinged for parental support. Okay, there is no way I'll be able to say these names properly. I'm sorry. So S and S from 1996. A mother failed to get support as her son claimed that it was really his grandmother who raised him and the mother wasn't able to prove otherwise. So she did not act as a parent and the other issues don't matter. If you don't have that one thing, if you can't say yes to everything, then you don't get support. And then Dragulin and Dragulin from 1998. This is another case that gets a lot of attention. So, a father sued his daughter for financial support. The judge found she had the means to pay. She had a good job and had won the lottery of just over $1 million. She disputed her father's right to support given he had verbally and emotionally abused her while she was growing up. The court found he qualified as a parent as he had paid child support for her. However, the judge found the father's demands lavish and awarded an amount less than asked for. So, what do you think about this result? So, because he paid child support, he was technically a parent, but he was abusive. So, should he still get any support if he abused his child? And then, just a little indicator here, the point isn't to give the parents an amazing lifestyle, it's what is an acceptable living standard for the time. All right, this is another case that's often referred to, Daskalov and Daskalov from 2007. In this case, the stepmother had been a parental figure to the stepson. He rented a home while his father and his stepmother lived in a house that he owned, the son. The father died, and the son lost his job because of illness. He could no longer afford the rent of his home, so he told his stepmother she would have to move out so he and his family could move into the house. She wanted him to either give her the house, which is kind of crazy under the circumstances, or sell it and give her some of the proceeds. Her application was denied because she actually had an income that was higher than the stepson's, and children shouldn't have to sell assets in order to provide parental support. There's also a third reason that takes too much time to explain. But again, we have the idea that children are allowed to have stuff and still not necessarily be required to pay parental support. Brash and Zima from 2014, a widow applied to get support from her late husband's estate. Her stepchildren were successful in having her biological children added to the case as also owing the widow support. And this is an interim decision. I couldn't find a final decision, might not be one, they might have settled or whatever. So this is the issue where she's suing the estate. Does she have access to other forms of support? This is the last case I'm going to look at, LFD and X from 2016. A mother failed to get an order for support from her daughter. The judge felt she didn't meet the needs test. She did have regular income and could, the judge thought, get a part-time job. The judge also considered the mother's financial history, in which she once had a lavish lifestyle and she had continued to spend carelessly even when her circumstances changed. So basically she kind of spent herself into this situation. Should her daughter then have to support her when it's due to the mother's bad financial decisions? And then, while the mother had technically provided both physical and financial care, she had been very abusive and had provided no care of any kind once the daughter moved out at the age of 16. So the daughter was still technically a dependent, and everything stopped when she moved out. So, as we can see, here's a bit of a difference where in another case they said, well, we're not going to look at the nature of the relationship per se because he had performed the role of a parent by providing child support. And in this case, they're saying, yep, the mother qualifies, but due to the nature of the abuse, she's not going to get anything. This is paragraph 396 from the case. These are the judge's words. Once again, it would defy all common sense and logic to permit a parent to indicate they provided their child with basic needs and even some luxuries, only to be compensated with parental support when they have been abusive towards their child over their lifetime. Would this not be rewarding the abuser and penalizing the victim? Does this not simply perpetuate domestic abuse? And I think we can agree, so now on to my words, that it does. I mean, this person, the adult child, even if they don't have to actually interact with the parent, send the money through e-transfer or whatever, they still have to think about this person every time they do that. And I didn't go into the abuse in this case, but it was pretty severe. This was a nasty piece of work. And so, should a child be in that position, they're actually supporting the person who abused them while they were vulnerable. And what we know is happening more is that, so now going to my words, more adult children are deciding their parents were toxic and abusive, that it will never change. So, for the sake of their mental health, they're saying, okay, parent, you're cut out of my life. I don't want to see you again. So if the parent ends up in poverty, should this adult child be expected to provide this support? On the other hand, it's also possible that an adult child is themselves the nasty piece of work and their parents were great, but they're cutting their parents out of their life. And let's say the parents poured everything they have into raising this child well, and that might be the reason that they've ended up in poverty. So in those circumstances, should the adult child be required to pay? So just something to think about. Is this a law you think should be enforced or that it should be thrown out? That's the end of this video. If you got this long, thank you for getting to the end of the video. If you like this content, it would be great if you clicked subscribe, and have a great day.